you're all doing well. Debt collection secrets. You don't owe third-party collectors. Shall we have a little look at this?
Did you know that most debt collection agencies are actually debt scavengers? Come over here and I'm going to explain to you why I believe that you should never pay a debt collector. Debt collectors typically, in most cases, are just debt scavengers. What that means is that they go to a creditor like Capital One, Citi, Bank of America, Wells Fargo, and they purchase a spreadsheet of debt. Now what they're doing is they're just buying an Excel spreadsheet with name, phone number, address, and the listed debt amount. They aren't actually buying any of the paperwork that really verifies and validates this debt. So what I find is about 90% of the time when we really go in and challenge a debt collector and ask them to prove the validity of the debt and to furnish the paperwork, they're really not able to. And you know what they'll do? If they're not able to furnish that paperwork, they've got to remove the account from your credit and stop contacting you. I never recommend that you just run out and go pay a debt collector before they validate that the debt is actually owned by them and that they have the right to collect on it. Even if a debt collector sues you, a lot of the time in court, if you have a good attorney, that debt collector won't be able to show the right paperwork. They're just accusing you without being able to show the proof. And since the debt collectors buy this debt at a significant discount, and we're talking pennies on the dollar, they only need to collect on a few of the accounts on that Excel spreadsheet to make their money back. And debt collectors are massive companies that make a ton of money. So don't fall victim to one of these debt collector scams. Request a validation, be aggressive, and know your credit rights. My name is Jesse Rodriguez with Credit CEO. If you found
So what this guy is saying is correct. You don't need to pay these guys. They will send you threatening letters saying if you don't pay it, we send the bailiffs around and so forth. But I find the best thing to do is send them a letter asking them to show you the contract that you signed with them for you to pay them your money that they say you owe them, if that makes sense. You see, if everyone stops paying them, those companies will be gone. And you will never have to pay them. Because what happens is, companies, you owe them money, and then they pass it on to the third debt collector. Well, they don't really have a right to do that. But yet, they still do it.
This next speech will deal with how to handle a collection agency that is on your back. As stated before, most agencies will have little to no background information about the debt they've been given to chase. This is a brief message designed to help make you aware of where you stand and how to turn the tables on them. Just because they're quoting words like legal or final notice doesn't mean they're acting within the law themselves. In fact, quite the reverse is often true, and what you may not know is that even their first letter or phone call, they're already on very shaky ground. Once they make contact with you, the first rule to remember is do everything in writing. No matter how angry their latest letter makes you, do not, under any circumstances, phone them. It's only a cost to you. If temptation does get the better of you and you feel you must speak to them, then do remember to record every call and keep precise logs of times and dates also. If they phone you, refuse to take the call and refuse to answer the security questions that they may ask you. Merely state that you do not deal with financial matters via telephone and that everything must be done in writing. Things get said on the phone that they would not in a million years dare say in a letter. First things first, ask them for a copy of their complaints procedure. Most collection agencies will not have one in place. If they fail to address your complaint or send you their complaints procedure, then this is sufficient grounds to report them directly to the Financial Ombudsman Service. Secondly, ask them for a copy of the original signed agreement as covered by the Consumer Credit Act 1974. Enclose a £1 postal order payment, making sure to keep track of the letter and the payment by recorded delivery. Wait out the 40 days that they have to deliver this information. If they send any correspondence in the meantime, you should do absolutely nothing, but do keep all correspondence to hand. The countdown is now on them, not you. Your sending the request for a copy of original signed agreement has now put the message across to them that the burden of proof is on their shoulders and not yours. In other words, despite the lying sack of shit and misinterpretations that they'll undoubtedly try to fob you off with, it is not up to you to prove that you don't owe them a debt. It's up to them to prove that you do. As I have stated in previous messages, under no circumstances provide them with any signature for anything they ask for. Forging of signatures is not above a collection agency. You should also make clear in your letter to them that the enclosed £1 payment is intended only for the purpose of paying for the copy of the document and under no circumstances should be misconstrued as a payment for the alleged debt. A collection agency that pockets the postal order, then tries to say it's an admission of debt, is being deliberately disingenuous. It is, in fact, leaving itself wide open to trouble and another complaint that will cost it more than you. You should also remember that you should not let said collection agency mislead you into thinking that the law doesn't apply to them, or them telling you that because they're not the original creditor, they don't have to provide you with the agreement. In short, any agreement with a corporation where you can pay by installments is covered by the Act. And if an agent is enlisted to recover the debt, then they do have to provide the agreement, especially if you ask and pay them for it. And they are well aware of this. A cursory glance of the Consumer Credit Act 1974 will reveal this. If they have failed to deliver the agreement in the time frame allowed by law, then they have committed a criminal offence. Once the deadline expires, you will be surprised how often this can be. Then you can also report a case of non-compliance against the agency to the Financial Ombudsman Service. But also make sure that your local trading standards office, their local trading standards office, Consumer Direct, the Information Commissioner's Office, and the Office of Fair Trading are made known of this also. Remember, no credit agreement, no chance of any court for enforcing the debt. Do not let anyone tell you otherwise. Also remember, if they want money from you, let them work for it. You have to work for the money that you earn, so why shouldn't they? Even if you do owe the money, that is not the point. Would you willingly pay somebody who threatens you in person? Why should it be at your expense to have them threaten you in person or by letter? It's still exactly the same thing. They're just trying daylight robbery on you, but just don't have the balls to do it in person. If you do owe the money, then deal directly with the original creditor. The agency has no powers at all to prevent you from doing otherwise. In fact, they won't like it at all, because they don't get their commission if you pay the original creditor direct. The other reason for asking for a copy of the original agreement is, how do you know that that agency is even acting on behalf of the original creditor? If they're saying that you owe them hundreds or thousands of pounds, you do want to make sure you're dealing with a legitimate company, and chances are you're not. If you do get sent information through, then there are plenty of websites, such as Consumer Action Group, Money Saving Expert, and many others, that will allow you to check whether the paperwork they have sent you is valid or not. All you have to do is type in bank charges complaints or scummy DCAs into a Google search, and there'll be page upon page of public forums that will give you all of the information you need to stop this harassment dead in its tracks. There are various criteria that such agreements must follow, and most such agreements that agencies send out would not be classed as valid in any court of law. Even if an agency has bought in the debt, then the same ground rules apply. Request a copy of the original signed agreement and also for a full financial breakdown. If they fail to give it to you, again, within the 40 days allowed by law, complain to the Financial Ombudsman Service. Remember that the Financial Ombudsman Service will charge the company for looking into any complaint, regardless of whether the Financial Ombudsman Service comes down on their side or yours. This is something else to realize, how far on thin ice the company actually is.
I want to leave it there and let you decide whether you want to pay it. I'll be in the business. God bless.